On October 12th, after being acquitted in a UAPA case for the second time, Professor GN Saibaba passed away in Hyderabad. His death once again brings to the fore questions on UAPA, whether it has any place in a society like ours, and the kind of flimsy grounds and flimsy evidence that the investigative agencies have used in these cases to keep people, activists and others, scholars and activists, in prison for long periods of time. Joining me now is Mihir Desai, senior advocate, who's also represented many of the people, including Professor GN Saibaba, who have been charged with UAPA. Now, before I go across to him, a quick request from all of us here at the News Committee. This kind of work where we are holding truth to power is essential in a democracy like India, and we're able to do this only because of viewers like you. If you like our journalism, then do support us by becoming a paid TNM and News Laundry subscriber. So I want to first thank you for joining us, and I want to get your first thoughts on the very unfortunate passing away of GN Saibaba.
Well, it is very unfortunate because for a period of 10 years, I was at some stage handling the case of his medical bail, etc. in Nagpur. So I had at that time the opportunity of going through his medical records. I had, of course, opportunity of talking to him when he was in jail. So I know that his condition was very, very bad. And it was just a miracle that he didn't pass away in the prison. Okay. Because of the conditions, of course, because of the kind of conditions, lack of medical health, etc., etc. So, but it is very unfortunate. It's the only silver lining I can see is that at least he was out for 8 months as a free person. But that's hardly a solace to anybody. And yes, he died because of certain medical complications. But I personally feel that those medical complications would not have happened, but for the fact that he had to suffer 10 years of incarceration. So that's how I look at it.
If we can talk about those 10 years, he was acquitted twice, but he still was not released. Can you take us through how, what were the ways in which the state ensured that he remains behind bars?
Well, see, look at it this way, that first, of course, my personal view is that his arrest itself was wrong. He should never have been arrested. I mean, he was a 90% disabled person, but not with any other health problems, but disability was there. He was immobile, okay, except through his wheelchair, he couldn't move anywhere. So he was not a flight risk or anything of that kind. I mean, he could not have run away anywhere. You could have put some conditions for a bail on him, etc., and he could have been. But his arrest itself was wrong because I don't think they found anything of substance from him, any evidence of substance from him to have arrested him. But anyway, he was arrested. After 5 years, 6 years, he was during the time when he was still under trial in the Sessions Court. Initially, medical bail was rejected. Thereafter, medical bail was granted by the Bombay High Court, the Chief Justice's Court, for the period of 3 months. In the meanwhile, he got convicted. So he goes back. So his medical bail is cancelled, though that should not have been cancelled, because whether you are convicted or acquitted, you are out on medical grounds, and that remains the same. But anyway, he was convicted by the Sessions Court. He's back into the prison. After he's back into the prison, then the matter goes to the High Court. There is an appeal filed by him and his co-accused in the High Court. That time, an application for bail is made on medical grounds. That is rejected. And his condition had worsened. You see, he virtually couldn't use half of his one side of his body. Leg-wise, he was absolutely paralyzed. He has a cyst in his brain. He had this gallbladder problem which was there, which ultimately led to his surgery. Okay? Was a surgery he needed 6-7 years back. Okay, and those records are available that he needed that surgery at that time. Okay, the medical records are available. So his heart was functioning at 55%, and even a very, very healthy man, if he spends so much time in prison, would become unhealthy by the time he comes out. And this man was 90% disabled, and that And I believe he should have been granted, if nothing else, he should have been granted bail. Anyway, he was not granted bail, medical bail at that time. Then the division bench of the Bombay High Court acquitted him on the grounds of procedural irregularities in conviction. Please understand that in criminal law, procedural irregularities matter a lot. That if you don't follow the procedure, you have to acquit a person or discharge a person. So on that ground, he was this thing discharged. The matter was carried by the state to the Supreme Court. Supreme Court in a special unheard of sitting on Saturday, because yes, Saturday sittings do take place. It's not that they don't take place, but not in case of acquittal. In case of granting bail, not for refusing, not for cancelling bail. I mean, I've never heard that ever before. So that happens. Then after that, for one more year, the matter lingers on in Supreme Court. Then the matter is sent back to the High Court, where the High Court finally again acquits them, this time not only on a procedural ground but also on substantive grounds. Then the matter is carried to Supreme Court. This time, of course, the Supreme Court says, "Sorry, we are not going to interfere in his release," and he's released in March. That this is how the things have happened.
There were also accusations that he was denied medical treatment in jail, at least to the extent that he required. And this is something that we've seen in many cases. We saw this in the case of Father Stan Swamy as well. Uh, do you know of other cases where under trials or even those convicted, especially under UAPA, are treated badly, are denied essential medical treatment in across jails in India?
Well, let me put it this way: that the conditions of medical health care in prisons is bad across the board. Whether you are a UAPA patient or you are not a UAPA patient, whether you are disabled or you are not disabled. Okay. So I mean, for instance, big jails are required to have hospitals. I know, for instance, Taloja jail, where some of these Bhima Koregaon people were incarcerated. Okay. It's supposed to have a hospital. Now, the hospital didn't even have an MBBS doctor, didn't have facility for even blood testing or drawing blood from simple things were not there. Okay. uh, you needed to have psychiatrists coming regularly, which was not happening. So what happens is that the medical conditions and the healthcare facilities in prison are abysmal. Okay, generally. Okay. uh, and so whether you are a UAPA detainee or not, they are abysmal. What happens with the UAPA detainee is that you are there for a much longer period of time. And because you are for a much longer period of time, the lack of healthcare affects you much more. Okay. It would be same for convicts. But so they are there for a longer period of time, and therefore it affects them quite a lot. And this has happened in Stan Swamy's case, as you mentioned, happened in Arothe's case, who died of swine flu inside the prison. Nobody could detect it was swine flu, and he died. He was inside prison at the age of 35. He died. So you have had many cases. Varavara Rao, lucky he got a medical bail and he's out. Otherwise, we don't know what would have happened to him. So, so the situation is quite bad. Yes.
So I want to talk about UAPA itself. There is a lot of conversation once again on, does it have place in a society like ours? Because if you look at the arrest, and you have represented many people who've been charged with UAPA, particularly in the Bhima Koregaon case, is there enough evidence to keep people in jail, or that is immaterial in cases of UAPA, and that's a huge concern?
Well, that's a huge concern. According to me, a law like UAPA should not find a place in a democratic country like India, for the simple reason that whatever allegations you are making, whatever offenses you are, uh, uh, yes, terrorism has to be fought legally also, apart from other ways. But the existing laws are there. Existing laws, whether it was the Indian Penal Code or Bharatiya Nyaya Samhita, whatever it is called now, okay, those laws do cover. Those laws can be effective. Those laws talk about waging war against the state. Those laws cover all those aspects. Those laws cover, arms act is there, terrorism. So all those laws can be used if you really want to tackle terrorism. Also, now with the new law, okay, there is a separate chapter on terrorism. Okay, where a person can be now. If you already have that, why do you need a separate law? Okay, but the only reason why you need a separate law, okay, from whatever I can understand, is to keep people behind bars for as long as you want to. Courts are very reluctant to release them on bail. Okay. Uh, the version of the police is, or the prosecution is believed prima facie. There are judgments of the Supreme Court which say that that version is to be believed till it is disproved. You have a situation where names of witnesses are not revealed to you at the time of bail. So you don't know what somebody is supposed to be saying against you. You have no way of countering it. Okay. So in this kind of a situation, and the bail conditions are harsh. So what happens is essentially UAPA is used not for convicting people, which a conviction may or may not happen. Nobody's bothered about that. Okay. It's essentially used to keep people behind bars for long years. You know, where, as people say, process itself is punishment. That's ideally true of act like UAPA. So I personally feel that you can achieve whatever your declared objectives are of fighting terrorism. Okay, even through the normal legal system, you don't need a special law to do that. Okay, you may at the highest need a special law only to ban a particular organization. Okay, which was what UAPA was till 1984, because UAPA came in 1967, and till 1984 it was not an anti-terror law. It was a law meant for banning organizations alone, nothing else. Okay, for 84, once POTA goes, then you have all those provisions incorporated in UAPA, and then UAPA becomes an anti-terror law. So as an anti-terror law, I personally feel that it should find no place in a democracy like India.
If you can talk about the evidence itself, the police don't have the burden of actually showing that any of the people arrested under UAPA are a threat to society, are a threat to the safety of certain people. That does give a long rope to arrest people on very flimsy, grounds and with very flimsy evidence. Isn't that true of even Professor Sai Baba or Stan Swamy and other accused?
I would say yes. They of course claim that they have adequate evidence. Okay, like what has happened, like they take away your computers. Okay, without any process whatsoever, and then they say this was found, that was found. Now, and as is obvious in the Bhima Koregaon case, which I am much more familiar with, that things seem to have been planted on their computers, so you can keep on showing these kind of things, planted evidence, and there is no way to counter it, though there are now US specialist reports that these are planted. There is no way to counter it till the matter goes for trial, which will be for God knows when, 10 years, 15 years, etc., etc. So you have a situation where you have very, very evidence which is only the say so of the prosecution, that we found this, or that he was talking to or that he had gone to Pakistan, like in Anand Teltumde's case, that he had gone to Paris. Yes, he had gone to Paris because the Paris University has invited him. But you can't use that because defense arguments cannot be used at the stage of bail. So the only thing, okay, this is how. Of course, now some of the judgments of the Supreme Court are quite. I think they are trying to balance out things. Okay, by releasing people who are in long incarceration, etc., etc. So that is happening, but that's not enough. You need. You didn't have to have a Stan Swamy or Arote or people like that dying in prison because of that. So that's my assessment. Yeah.
Even in the case of Professor Sai Baba, they talk about umbrellas and bananas, and him possessing supposed literature related to the Naxal movement. Is that, in your informed opinion, enough to incarcerate somebody for 10 years? Take away ten
No,
years
it's
of
not.
someone.
It's not enough to incarcerate somebody for one day or 1 hour. Okay. So, but the problem is this: that even after acquittal, okay, Sai Baba is acquitted, right? I'm sure many of the most all of the Bhima Koregaon people will be acquitted at the end of the day. But there is no punishment for people who file cases and keep them inside for 10 years. The officer, the prosecuting agency. So why should they bother? I mean, the same prosecuting officer would not blink an eyelid before putting somebody else in jail for 10 years because he knows nothing is going to happen to him. At the highest, what will happen after 10 years? Somebody will be acquitted. Fine, doesn't matter. We kept him inside for 10 years. There is no consequence for us. There is no repercussions on us. Yeah. A complete lack of accountability, total lack of accountability, which leads to it. You make people accountable. You order on acquittal compensation and at least compensation for people who are acquitted. Okay. You do that. You start doing that, and you will see the change. People will be scared to then, you start paying compensation from salaries of the officers who incarcerated them to begin with, and you will see the change. But they don't want to, do that.
If I can ask you another question on the use of this literature, possession of certain kind of literature as the primary evidence in so many cases, how wise is that, and how is that something that you think should stand in court? Because in
Look,
many of these cases,
look,
that's
look.
all we see.
I argued in court that I like reading all kinds of things. I have camp at my house. Okay, I have Das Capital at my house. Okay, just because I have Mein Kampf doesn't mean I am a votary of Hitler, and just because I have Das Capital doesn't mean I am necessarily a votary of Karl Marx. Okay, so people have all kinds of literature. You go on the road, okay, somebody is distributing literature, you pick it up. Okay, free literature. It may be by some revolutionary party or something. You pick it up, you bring it home, you read it, you keep it aside, etc., etc. Unless that particular, you see, there are laws in our country which allows certain books to be banned, certain material to be banned. So unless that particular material is banned, okay, unless that book is banned, how can you charge me with? And you see, academy, especially for academicians, for journalists, etc., etc., you would be accessing all kinds of material. That doesn't mean you actually believe in that. Okay? And the point is that even if I believe, take for instance, if I believe in my mind that all Muslims should be killed, okay, suppose I believe in my mind, that's not an offense under the law. That's not an offense because freedom of conscience is there. I have a right to believe that. I don't believe that. I'm just making it clear for your audience that I don't believe it. But I'm just telling you that even if I believe that, unless I act on it, okay, unless I act on it by doing something, by giving speeches saying that kill everybody, kill all Muslims, something like, unless I act on it, it is not an offense under even our present law. So merely having literature, merely having access to literature is, I mean, today you open internet, you will be able to see all kinds of things. Okay. And there'll be sites, I guess, which say that how to make a bomb. I don't know. There might be sites. And once you open your internet, anything can be seen. So similarly with literature, I mean, I don't personally believe having literature can at all by itself be a ground for arresting somebody.
Can you tell us about some of the other more, I use the word flimsy, but unsubstantial so-called evidence that have been put forth in front of the court in UAPA cases?
I mean, there are cases where lawyers are arrested, for instance, okay, for assisting their clients. Okay, I mean, they won't say that we are arresting you for assisting your clients. They will put a veneer of illegality in their actions, kind of thing. Okay. You will have people. I mean, literature is one thing which is very clear that somebody was found with literature, or somebody was. See, how many of these cases you actually find people with guns or arms? Okay, that's one question. Very, very rarely. Okay. Uh, and even there are allegations that some of them are planted. Okay, even when you find people with blah, blah. But forget that. How many people you actually find with arms and ammunitions? Nothing. How many people from whose houses you recover some great amount of money and all that? Nothing. Okay, that doesn't happen. These are just kind of fairy tales. Okay, at times. Sometimes it may be true. I'm not saying that everything is untrue. But many times these are just fairy tales woven. Okay. A narrative which is set in place. Okay. Repeatedly told to people, and people start believing that narrative. Okay. So, the kind of evidence, in fact, if you want to charge somebody with terrorism, you really need some serious evidence, uh, because terrorism is a serious crime. And look at the situation. A person is in jail for 10 years. Look at Sai Baba. 10 years he's in jail. His family life is ruined. He loses his job. At the end of 10 years, when he comes out, he doesn't get his job back. Okay. So then, otherwise, he would have been he would have taken another 3 years to retire, and then pension, family pension, etc. Even assuming he had passed away. Okay. The family would have been well taken care of, etc., etc. All that goes, no? All that goes away. And you see, I have my opinion is a lot of this evidence, okay, is very flimsy. Yeah. Lot of it. I'm not saying all of it. Again, let me be very cautious in what I'm saying, because I'm not saying everybody who is arrested is wrongly arrested or something like that. But some of the cases which I've seen, the evidence is really flimsy.
That was senior advocate Mihir Desai, who is making it very clear that in India there's absolutely no requirement for a law like UAPA, and there are enough provisions in our law to handle cases that come under UAPA if there are any illegal activities.